I'd like to welcome Minister Lenihan to the House. We're on item number 1, statements on the importance of protecting intellectual property rights. Antara.
I suppose before getting into the bulk or the main part of my speech here on intellectual property, I think it might be timely and appropriate if you can, to open up on some issues pertaining to the recent court case, which I think has to a large extent motivated the motion before the House here today. The recent judgment by Mr Justice Charlton in the High Court case between EMI Records Ireland Limited, Sony Music Entertainment Ireland Limited, Universal Music Ireland Limited, Warner Music Ireland Limited and WA International Incorporated on the one hand and UPC Communications Ireland Limited on the other is a very important one, and one which is being examined very, very carefully. Essentially, the recording companies concerned sought injunctions against UPC, an internet service provider, in relation to the downloading of copyright material over the internet, and the court declined to grant such injunctions. The area concerned is a very complex one, and it encompasses issues such as the illegal downloading of copyright material, the treatment of internet service providers, which are known as ISPs, in such circumstances, and the obligations imposed by Member States by the European Union law, and the upcoming requirement for Ireland to transpose the 2009 Framework Directive on a common regulatory framework for electronic communication networks and services. Justice Charlton's judgment is a lengthy one, running to 78 pages, and in its ruling it ranges across the various provisions in copyright, e-commerce and national telecommunications legislation and the relevant European law.
Dr. Minister, I'd like to just ask for guidance through the Chair. I don't see any of this in the script that I've received.
Sorry?
I don't see the material the Minister is referring to in the script that I've received.
That's why, Senator, I said at the very beginning I thought it would be timely to deal with this.
Very helpful, but I thought you were reading it and I wondered if it was possible to have a copy
we'd certainly try to provide you with one. I think we have one here.
Because I think you're right, Minister, the Charlton judgment goes to the heart of the thing, and if it's possible, it would be very helpful. Thank you very much.
As I said, Justice Charlton's judgment is a lengthy one, running to 78 pages, and in its ruling it ranges across the various provisions in copyright, e-commerce and national telecommunications legislation and the relevant European law in each of those areas. Having obtained a copy of the judgment, my department referred it to the Attorney General's office for their advice, and this advice is currently awaited. Clearly, as Minister with responsibility for intellectual property, I am concerned to ensure generally that the interests of rights holders in respect of copyright and performances are upheld and are not infringed by illegal activity on the internet or elsewhere. I must also, however, have regard to the position of our internet service providers. Articles 12 to 14 of the European e-commerce directive, for example, provide defences to internet service providers who transmit digital content, including copyright material, by electronic means on the internet. These have been transposed in Ireland through Regulation 16 to 18 of Statutory Instrument No. 68 of 2003. Regulation 16 provides that internet service providers are not liable for information transmitted by them in a communication network where an internet service provider establishes that it is a mere conduit or carrier of the information. Regulation 17 similarly covers caching or temporary storage. Regulation 18 deals similarly with hosting or permanent storage. However, these regulations do not affect the power of any court to make an order against an internet service provider requiring that the provider not to infringe or to cease to infringe any legal rights. Both my department and the Department of Communications, Energy and Natural Resources, headed up by Minister Ryan, are in contact in relation to the case, but as the advice of the Attorney General as to the implications of the case is awaited. Senators will appreciate that I am not in a position to speak further about the case or its potential implications at this point. It is a hugely sensitive matter, and I'm sure the Senator Norris is acutely aware of that. In opening my address here, I want to address two distinct issues related to the importance of protecting intellectual property. I will firstly address the importance of intellectual property protection to business and the state supports for a strong innovation environment. Secondly, I will address the importance of having a sound and balanced regulatory environment for the protection of intellectual property. The concept of intellectual property covers a wide range of creations of the human mind, from the inventions, symbols and designs used in industry to literary and artistic works. The most common vehicles for protecting intellectual property rights are patents for inventions, trademarks for branding, and copyright for artistic works such as books, films, and paintings. Intellectual property protection and innovation are inextricably linked. The products resulting from innovation generally come at a considerable cost to companies in terms of human and financial resources. It is the facility to protect the fruits of this investment with intellectual property through patents, trademarks and copyright that provides the incentive to industry to invest in research and development. Patents are the most valuable assets to companies seeking to protect innovation. Patents are central to supporting innovative companies across the business sector in several ways. Firstly, they add economic value to inventions by giving them a monopoly for a fixed term. This can help secure funding for commercialisation of inventions and bring products to the market, which leads to profitable commercial returns. Secondly, they allow for the circulation of cutting-edge technological information. In exchange for the monopoly right gained in a patent, applications are published after an initial period from their filing or priority date. This encourages both inventors and their competitors to research further developments arising from this information and often results in further technological advances and breakthroughs. Thirdly, patent licenses encourage inventors, investors and manufacturers to cooperate. This particular cooperation linkage is key to innovation. Licenses are the key means of exchange in the knowledge society marketplace for ideas and often result in furthering the research and cutting the time to market. Trademarks facilitate the development of branding and enable consumers to identify a product or service of a particular company and help to distinguish one product from other similar products. Trademarks are often associated with certain characteristics of goods or services such as taste, quality, reliability or value for money. A strong trademark associated with a successful product can ensure the continued success of the product even after a patent has expired and competing products become available. It's important for business to register and protect their trademarks so that quality goods and services are identified with their trademark by their customers. It's widely accepted that a high level of copyright protection is generally essential for the encouragement of intellectual creation. Copyright ensures the maintenance and development of creativity in the overall interests of authors, producers, consumers and of course the public at large. A rigorous and effective system for the protection of copyright and what are deemed to be related rights is necessary to provide authors and producers with a just reward for their creative efforts and also to encourage producers and publishers to continue to invest in the creative process and indeed in creative works. In the modern world of business, the intangible assets of a company are often more valuable than the company's physical assets. Identifying and protecting the intellectual property in a business can increase competitiveness and assist the business in a variety of ways, such as building a strong branding strategy, providing access to capital, or through profitable licensing agreements. It's imperative that Irish companies, particularly small to medium-sized enterprises, understand the importance of protecting their innovation, their innovative products and services through the use of intellectual property. The importance of providing an environment for business in which innovative ideas are encouraged and rewarded has long been and continues to be a core objective of this government. Commercialisation and the transfer of technology flourish where intellectual property rights and the know-how associated with it are guaranteed and legally enforced. Ireland's legislative framework in intellectual property and in other relevant fields enables companies here to create, protect and exploit their intellectual property assets. An additional important consideration is that it provides researchers in our third level institutes with the means and incentive to commercialise this intellectual property for the benefit of industry and ultimately the Irish economy, taxpayers as well. Over recent years, the government has been implementing measures that encourage the development of intellectual property by means other than intellectual property regulation. And this has included a range of supports to encourage commercialisation, technology transfer and the generation of intellectual property where possible and feasible. There are two reasons why the state provides this support. One, to increase the level of intellectual property transferred to industry from research in higher education institutions for the benefit of the economy. And secondly, to facilitate the development of high quality and effective systems and policies to ensure that the intellectual property is identified, protected, transferred and where possible into companies in Ireland. These have both been identified by the recent Task Force on Innovation as key priority areas for improving and growing Ireland's fabled knowledge economy. Enterprise Ireland provides a range of supports to encourage the generation of intellectual property. These include specialist support to third-level institutions in identifying and exploiting intellectual property, financial support for research and resulting intellectual property protection, support for emerging start-ups and linking inventions emerging from different universities and educational institutions where appropriate. Enterprise Ireland also funds commercialisation specialists in the technology transfer offices of these third-level institutions. This measure supports a network of dedicated staff placed within the commercialisation function of the universities and institutes of technology, and working directly with them to ensure that the best use is made of the research outputs with commercial potential. The supported intellectual property provides a vehicle that is critical to the successful licensing of academic research to existing spin-off or campus companies, and this way encourages products based on the technology to reach the marketplace and reach the customers. Ireland's tax system has for some time encouraged both the creation and management of intellectual property by means of our 25% research and development tax credit, our patent royalty exemption, and most recently our new 2009 IP tax deduction regime, along with making Ireland an attractive environment for foreign direct investment with our 12.5% corporation tax rate. Effective intellectual property rights enforcement is an essential part of protecting the health and safety of individuals, because certain counterfeited products such as medicines, foodstuffs, body care articles and children's items that are produced in an unregulated environment can pose a serious health threat to the public and to the final end users. It's very important that we recognise the link between intellectual property crime and organised crime. Organised crime groups use the trade in fake goods to generate profit and to fund other forms of organised crime such as human trafficking, money laundering, firearms and illegal drugs. The internet and digital technology have presented criminals with an efficient, high-speed and anonymous way to conduct IP crime across borders and continents. While luxury goods have traditionally been targeted for counterfeiting and piracy, today a wider variety of mass consumption goods, foodstuffs, cosmetics, spare parts for cars, toys and various types of technical or electrical equipment are affected by this piracy. Due to the clandestine nature of many counterfeiting and piracy activities, it's difficult to accurately assess their scale. The OECD published a report in November 2009 that confirms that counterfeiting and piracy of tangible goods is a major impediment to global trade and is in fact getting worse. The report estimates that global trade in counterfeit and pirated goods more than doubled in this decade to approximately $250 billion in 2007, up from just over $100 billion in 2001. That figure does not include goods produced and consumed within countries. The real figure is therefore possibly far higher than that estimate. The international scale of the problem is also clear at a European level. The European Commission's annual report on EU customs actions shows an upward trend in the number of goods suspected of violating intellectual property rights. In 2009, over 43,500 cases of such goods were stopped by customs, totalling 118 million articles or items. It's clear from even a quick glance at these issues that the nature of IP crime means that it must be tackled at a national and international level. This requires a collaborative approach between state authorities and the private sector. A number of important initiatives at international level are underway. Within the European Union, there are already a number of legal instruments in place, including the Enforcement Directive. But in order to make them more effective, the European Council adopted a resolution on a comprehensive EU anti-counterfeiting and anti-piracy plan. This resolution endorsed the need to step up the fight against fake goods. In 2009, the European Commission launched the European Observatory on Counterfeiting and Piracy. The observatory is composed of members from both the private and public sectors and is intended to raise awareness and share information and best practices in enforcing intellectual property rights.